Trust in family law. If you have assets in a family trust and you're going through a separation, the biggest question you need answered is this: will the court treat those trust assets as yours in the property pool, or will they stay outside the division? Most people set up trusts believing they are protected. Your accountant probably told you it's for tax planning and asset protection. But when family law gets involved, those same structures can either shield your wealth or become your biggest liability, depending on how they've been used. In family law cases involving trusts, I see two types of clients: those who understand how courts look through trust structures early and plan strategically, and those who assume the trust protects them automatically, only to discover at settlement that the court treats it as theirs anyway. So today, I'm breaking down the two outcomes courts use: the control test that decides which one applies to you, the exact documents you need to pull, and the red flags that trigger extra scrutiny. By the end, you'll know whether your trust is vulnerable or what to do about it. This could just save you from handing over thousands of dollars in assets you thought were protected. First, let me show you what's at stake if you get it all wrong. Let's say your family trust holds a $1.2 million investment property, $300K in retained earnings from your business, and another $150K in loan accounts you've drawn over the years. That's $1.65 million. If the court treats the trust as property in the pool, meaning they see it as effectively yours because you control it, the entire $1.65 million gets added to the asset pool for division. Now, if you're looking at a 60-40 split in your partner's favor, you've just handed over $660,000 of what you thought was protected wealth. But here's where it gets worse. If the trust owns a trading business and the court orders you to pay that settlement amount now, you might be forced to sell business assets or refinance under pressure, disrupting cash flow, staff, and clients. The cost isn't just financial, it's operational. On the flip side, if the trust stays outside the pool and is only treated as a financial resource, the court acknowledges that you benefit from it, but it doesn't get carved up. Your settlement stays lower, you keep operational control, and you structure staged payments if needed. The difference between these two outcomes can be $400K or $600K, sometimes even more. And it all hinges on how the trust has been actually used, not just what the trust deed says on paper. So let's talk about how courts decide which outcome applies to you. Australian family courts look at trusts and ask one question: is this trust genuinely independent, or is it just an extension of you? So because of this, there are two possible outcomes. Outcome one: the trust assets are treated as property. This means the court includes the trust in the property pool for division. You are treated as if you own it, even though technically the trustee holds a legal title. This happens when the court finds you have effective control. You're the one making decisions, benefiting from distributions, and using trust assets like your personal bank account. Outcome two: trust assets stay outside the pool but are treated as a financial resource. Here, the court acknowledges you have access to or benefit from the trust, but doesn't include it in the divisible pool. Instead, the judge considers it when deciding what's just and equitable, so it might slightly adjust your percentage, but the trust itself isn't split. This actually happens when control is genuinely independent. Maybe your parents are the appointers and trustees, distributions go to multiple beneficiaries, and you are just one of many. This distinction matters enormously. If it's a property, it's divisible. If it's a resource, it stays intact, but might influence the final split. So how do courts decide? They trace power, not labels. They don't care what the trustee says you could do in theory. They care what you actually did in practice. So here's the framework courts actually use, and most people miss half of these factors. Courts look at two things: powers in the trust deed and conduct in real life. Powers mean who is the appointer. The person who can hire and fire the trustee holds the real power. Who is the trustee, and can you remove or replace them? Who decides distributions? Who are the beneficiaries, and can that be changed? Conduct means who actually signs trust resolutions. Where do distributions go, one person or spread across multiple beneficiaries? Whose personal expenses get paid by the trust? school fees, cars, holidays, home renovations. Who uses the trust bank account? Is it treated like your personal wallet? Here's the insider secret most people and even some lawyers miss, and it's what I call the paper trail reset strategy. If your trust has been treated like your personal account for years, but you are now facing separation, some people think they can suddenly restructure, appoint an independent trustee, and change distribution patterns right before proceedings. Courts see straight through this. In fact, last-minute changes around separation increase scrutiny. Judges will look at historical patterns like the last 3 to 5 years of distributions, who benefited, who signed resolutions, and what the trust paid for. If it walks like your personal account and talks like your personal account for 5 years, restructuring it in 3 months before mediation won't save you. But here's what does work. Early, genuine restructuring before relationship issues arise, or being transparent about historical use and negotiating settlement options that preserve business continuity, like stage payments or offsetting against other assets. The key is understanding your position early and planning around it. Now, there are 3 traps that will blow up your position if you don't catch them early, and each one hands ammunition directly to your ex-partner's lawyer. Red flag number 1, the loan account. That's actual distributions. If you've been drawing money from trust via loan accounts year after year without paying them back, courts treat those as distributions to you. They are evidence you control and benefit from the trust. If your loan account has ballooned to $200,000 with no repayment plan, the court sees that as your money. Red flag number 2, last-minute liabilities or asset transfers. If suddenly, around separation, the trust takes on a big new debt to a related party or assets get transferred out to family members, courts will ask, was this genuine commercial activity or was this designed to defeat the other party's claim? If it smells like asset protection tactics done in bad faith, judges can add back those amounts or set aside those transactions. Red flag number 3, the missing trust deed or sloppy records. If you can't produce the trust deed, trustee resolutions or financial statements is signals to the court and to your ex-partner's lawyers that you are either hiding something or the trust was run informally, which usually means you were running it personally. Always keep clean records. Deed, any variations, appointed documents, trustee meeting minutes, financials, tax returns, distribution schedules. The protective move here is this. If your trust is vulnerable, meaning you likely have effective control, don't hide it. Instead, negotiate settlement structures that protect business continuity. Options include offsetting. You keep the trust, they get more of other assets like super or property. Stage payments, spread settlement over 2 to 3 years to avoid fire sale disruption. Refinancing structures, pull equity from trust assets without selling them. At the end of the day, courts respect transparency and practical solutions and are more likely to punish evasion. You now know 2 outcomes, the control test courts use and the red flags that trigger problems. But here's what most people need to understand next. What happens to your super when you separate? I've just filmed a video where I walk through how your super is managed in the separation process, what you are legally entitled to, and how to protect your assets at the same time. And if your situation involves trust and separation and you need strategy advice specific to your case, we handle these type of matters. There's a link below to book a confidential call with our team. We'll review your trust structure, assess the likely court treatment, and map out settlement pathways that protect your business. But either way, start by getting those documents together. The earlier you understand your position, the smarter your settlement strategy can be.